Hello, I want to invite you yet to another important area, which is on other characteristics of good evidence. Previously, we looked at evidence, sources of evidence, and types of evidence. So today, I want us to look at what makes a piece of evidence good. And therefore, when utilized in a judicial proceeding, it enhances chances of conviction for the prosecutor or acquittal for the defense team. So basically, we want to look at some of the criteria that are used to evaluate whether or not a piece of evidence to be adduced in court is good. Welcome. Maybe we need to begin by having a recap on what is evidence. Evidence refers to a term that is commonly used to describe the supporting material that is utilized when informing or persuading others. And evidence offers support to claims and thereby elevating our arguments beyond mere collection of personal opinions or prejudices. Types of evidence that are used in criminal cases are numerous. As we noted in our previous discussion, they include testimonial, anecdotal, statistical, textual, corroborating, and even inculpatory evidence. Therefore, these are the major types of evidence, and also in our previous discussion, we observed that evidence can be sourced from a variety of sources, including authority, empirical research, personal experience, as well as testimonials. Now, when we talk about evidence evaluation, we simply mean the objective and systematic examination of the suitability and appropriateness of evidence that is used or to be used in a criminal case. I noted and observed earlier that for the defense team, they want to present evidence that is capable of having the accused acquitted, that is, freed of charges or accusations that have been leveled against him or her. But for the prosecution side, they are relying on evidence which, in the opinion, is strong enough to have the accused convicted. We said that the evidence that the prosecution side relies on is called inculpatory. Then the one that the defense team relies on and in which they seek to lay bare before the judges or courts of law is called exculpatory evidence. So what then are some of the criteria that we use or employ when we are evaluating evidence? One of the things that we look at when we're evaluating evidence is about relevance. And by relevance, we mean the degree or the extent to which evidence is related or useful to the crime being committed. The evidence being sourced should be specific to the reasons for which it is being provided, either supporting or refuting a claim. Evidence being sought should therefore either support the claim against the suspect or exonerate the suspect from claims leveled against him or her. It is therefore important for the claimant or the accuser to first consider whether and why the evidence being sourced is necessary and relevant to the case in question. For instance, if, say, somebody is being accused of murder, and all the evidence therefore should point to murder and should either be used to show that the person actually directly or indirectly participated in the murder or did not. So that if somebody now brings evidence that speak to, say, an issue like forgery, then that might not be relevant to the case at hand, unless there is a clear justification that what caused the murder was probably linked to an earlier case of a forgery. So every evidence that is presented in a court of law that seeks either to have the accused convicted or acquitted must of necessity speak to the case at hand. Otherwise, on the basis of lack of relevance, that evidence might either be rendered completely unsuitable or weak enough not to succeed in terms of whether it sought to have the accused convicted or have him or her acquitted. So relevance is an important aspect that at all times must be observed when we are evaluating whether or not a piece of evidence beforehand is important, rather is suitable for the case in question. The other important consideration is that one of accuracy. By accuracy, we mean the extent to which the evidence being relied on is true, correct, and devoid of errors. Accuracy of evidence can be ascertained through juxtaposition with relevant measurements and internationally recognized standards. For instance, lawyers consider the Black Law Dictionary as a standard source of definitions of legal terms. Economists consider World Bank standards as a main reference to aspects such as poverty and standards of living. Again, in Kenya, the Kenya National Bureau of Statistics is regarded as the main source of statistical information. Central Bank, the main source of monetary information. The DCI, the reference point for criminal information and statistics, among others. So every evidence that is being provided must be accurate. Otherwise, any evidence that lacks accuracy might be questioned and might be found as not being suitable, and therefore not adequate to render the accused convicted or acquitted, depending on which side of the case has tabled evidence that is not accurate. So it is important that the evidence that we present in any legal proceeding must be true, must be correct, and must not have certain errors. So accuracy is key and also an important consideration that all times must be borne in mind when we are evaluating the extent to which a piece of evidence that we intend to use either to convict or to acquit the accused in any criminal proceeding. The other important consideration is that one to do with completeness. And what do we mean by completeness? Completeness refers to the extent to which evidence represents or captures all the relevant information. And completeness implies that evidence provided in support or rejection of a claim should be comprehensive and adequate in coverage, and this is achievable through what we call horizontal and vertical sourcing of evidence. Horizontal sourcing of evidence implies that seeking evidence from several areas of the same source. For example, considering several authorities when we are using authority as our main source of evidence, or so that not just one authority is sought. Again, horizontal sourcing refers to seeking evidence from different sources with a view to demonstrating patterns of convergence and divergence. That is, where do particular sources of evidence agree, and where do they agree? So completeness of evidence therefore relates to the depth and multiplicity of sources of evidence. Indeed, we do not just want a mere piece of evidence for the sake of it. We want evidence that is comprehensive, that is complete, and that is adequate enough to demonstrate that indeed a particular uh, 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 a particular person that is being accused of having committed any crime actually committed a crime, if it's the case of the prosecution. For example, assuming a person is being convicted of murder, is being tried for murder, and there is evidence that uh, is being used in a court of law, for example, forensic evidence, and maybe the person just took one aspect, communication that probably the person engages in with maybe the people that he or she hired as hitmen is not analyzed. So when you don't analyze other aspects of evidence to present a case that actually demonstrates that the suspect was at the center of crime in terms of coordination, in terms of hiring, even in terms of paying the people who committed murder, then that piece of evidence might not be complete, and in the process, it might be rendered inadequate or shallow to have the accused actually get convicted. The other important consideration that is used is what we call currency. Currency relates to how recent is evidence being used to support or refute a claim. So that in some instances, evidence that is over 5 years old may generally be regarded as old. Recent evidence is therefore crucial as they help claimants reflect on the latest findings and consensus on a given subject or issue. Old evidence can still be important when advancing foundational knowledge or historical perspective of a claim. How context shape both new and older sources. That is still important. But old evidence might also be essential when demonstrating the evolution or the development of an idea or issue, the progress of thought over an idea or a subject matter. And all these cases, uh, they are actually useful. For instance, if we are using judicial proceedings or what we call judicial precedent as our source of evidence, then we need to consider the most recent judicial precedent as as our evidence, because certain precedences that occurred earlier may be invalidated or affirmed by recent court rulings. So we have to look at the latest case of evidence, and that therefore can be relied on to demonstrate that a matter at hand is actually can lead to conviction or acquittal, depending on the perspective of the side in which we take. So most recent information is considered more important. But like I've said, it is not that all circumstances you must rely on the most recent information. Sometimes you might want to rely on all the information if you want to bring forth or to lay bare the foundational knowledge or a historical perspective of a given issue. And also when you want to demonstrate how a given line of thought, legal or criminal thought, has evolved over the years, then in that case, therefore, you are at liberty to employ uh, old evidence. The other important consideration that we employ when we're evaluating the extent to which a piece of evidence is good, or one of the characteristics of good evidence, is what we call credibility. Credibility refers to the extent to which evidence is true, trustworthy, and factual, and therefore believable and reliable. Credible evidence add weight to the claim, thereby ensuring that they stand up to scrutiny and integrity. Witness credentials and reputation. In other words, you check the background of the witnesses, even if it is institutional sources, institutional affiliation, among other standards, so that a credible evidence is one that is sourced from a credible source. If it is proven, for instance, that the witness that is standing before a legal proceeding lied or has a tendency or history of not being trustworthy, then the evidence that is used or that he presents in court can actually fail the test of credibility. It is therefore important that at all times, credibility of the evidence is properly examined and ascertained, because if that does not happen, then it can raise a lot of questions. Credibility, as I've said, is the extent to which the evidence is true, the evidence can be trusted, and also the evidence is actual. If evidence is true, it is trustworthy and factual, then such evidence can be believed and therefore can be relied on in any judicial or quasi-judicial proceedings. So it is important at all times that we look at the type of evidence that's available and ensure that we present evidence that bears the most important characteristics, like the ones that we have looked at: credibility, accuracy, among other aspects, because it is the duty of the investigator to ensure that they do not, out of malice, collect or implicate a person as having committed crime when in actual sense the person has not. Such malice can only be, the doubts about malice can only be raised when proper, reliable, accurate, complete evidence is presented in a court of law. If any piece of evidence do not conform to these characteristics, then the defense side can actually dismantle each of the evidence and prove them as being too little or ineffective in terms of having the accused being convicted. And the process now, the adjudicator, the judge, the magistrate, and others that are presiding over such cases might find that the evidence presented is too inadequate and therefore have the accused released. Up to that point, I want to thank you for your time, and I want to ask you to listen to the discussions and note down any issue that you find either not adequately explained or that you need further explanation or clarification. Thank you so much for your time.